Let's take a look at how long it takes to bring a case related to employment. An important feature of any enforcement procedure is the length of time that an aggrieved person has to come forward with a complaint. This is the limitations period. Time limits for filing lawsuits or charges with administrative agencies vary. Unfair labor practice charges must be brought to the National Labor Relations Board within 6 months of their occurrence. In discrimination cases, employees generally have 300 days to file a charge with the Equal Employment Opportunity Commission, but only 90 days to file suit if the EEOC's efforts to resolve the case conclude unsuccessfully. This means employers must be prepared to defend actions taken well in the past by individuals who might no longer work for them. The only way to do this is to maintain solid documentation regarding all human resource decisions. Employees who fail to bring charges in a timely fashion generally lose their right to pursue legal action. The clock usually starts ticking when the employee receives notice of a decision rather than on the effective date of that decision. This is known as equitable tolling. This doctrine is applied sparingly and generally does not shield employees from the consequences of negligent legal representation. When applying limitations periods to discrimination cases, courts distinguish between discrete acts, such as nonhiring and termination, that occur at particular points in time, and acts that recur and have a cumulative impact. Repeated acts of harassment that over time create a hostile work environment are a prime example of the latter. Employees who claim that they have been subjected to a hostile work environment can challenge all of the harassing acts, even if those go well beyond the limitations period, provided that at least one incident of harassment occurred during that period. Sometimes, employees claim that harassment or other discriminatory treatment leaves them with no option but to resign. An employee who quits under these circumstances is sometimes found to have been constructively discharged. The Supreme Court has said that the limitations period in such cases begins when the employee gives notice of her resignation, rather than on the date of the last discriminatory act that prompted the employee to quit. What about pay discrimination in this light? Is it a discrete act in which a decision is made at a particular point in time to pay an employee a discriminatory low amount? Or is it an ongoing violation that recurs with each paycheck? Congress enacted the Lilly Ledbetter Fair Pay Act, which established that each low paycheck is a separate violation that starts the limitation period anew.